Hi, Council. Just give me 1 second. Do we need a record?
Yes, please, Your Honor.
DC 19-02495. Council, please make your appearances.
Your Honor, my name is Bob Lamb. I'm the Thompson Co. Cousins Irons in Dallas, and I represent Armanino.
Your Honor, I'm Michelle Daniel of Counsel with Kennedy Law, representing Alliance Family of Companies.
Stephen Kennedy, also representing Alliance. Ms. Daniel will be making the argument.
Your Honor, Jeff Travis, here on behalf of the plaintiffs, Justin Magnuson and Don Jacobs.
So before we begin, I really want to understand where you all are in your attempts to confer. My reading of the motion and various replies and responses left me questioning whether or not you all have discussed specific search terms, limitations on time scopes, limitations on other scopes to the requests, so that the only things that are before the court here today are those with which you do not have agreement.
So, Your Honor, I'll start. It's my motion to compel, and it's Alliance's objections to Armanino's request for production. Mr. Kennedy and I have discussed traded emails several times, and his last email or his offer of production is what is in his reply brief, and that came in day before yesterday, and that night I filed sent to him my comments that in some case measure said, okay, your search terms are all right, but your people are not. And here's the additional people that I need. And he hasn't had time to reply. Now, as far as time.
He has not had time to reply.
I'm sorry?
He has not had time to reply.
That's correct, because he got it 10 o'clock night before last. And I'm sure he's got lots on his plate. So, on time, we've limited it to a 3-year period, 2015, 2016, and 2017. And our amended reply brief in a footnote explains that all of those time periods are tied to the allegations of the plaintiff. The other thing that really drove me to say I'm not going to be able to resolve this without the help of the court is Alliance's demand that I withdraw my subpoena. And I don't know what I'm going to get from them. And I don't want to have to start this process all over again if what I get is not adequate. I just don't know what I'm going to get from them. And by the way, I want to make plain here, my comments are not aimed at Ms. Daniel or Mr. Kennedy. I think that they're taking their instructions from Alliance. That's the obstacle. It is not Alliance's counsel. The other thing that is not stated in the records, but at least in one of my conversations with Mr. Kennedy, he made it plain that if he and I are able to strike a deal, that I only get one shot at these documents, that this, whatever is produced as a result of the deal that I get, that's all I'm going to get from Alliance. And I think that's driven by Alliance's general counsel, Pam Wagner, who filed an affidavit in their certified brief. She basically just doesn't want to be bothered. Now, I can't do that either. Here's a prime example. The plaintiffs allege that they suffered a reduction in price from $125 million to $95 million, which was the sale price for Alliance. And they allege that that price was driven down by the buyer because of a review of the medical coding used by Alliance that was under review by the American Medical Association. Well, I didn't learn until I received Mr. Kennedy's reply day before yesterday, that the review is actually conducted by the Medicare people. In the exhibits, you'll see a reference to CMS as conducting the review, and that's the Center for Medicare and Medicaid Services. Now, I haven't been able to discuss that with Mr. Kennedy. They may be willing, under certain parameters, to provide whatever they know about that review. But that's a classic example of I'm going to need the ability to follow up with Alliance on what they produce.
Okay, let me stop you there. And first, I do appreciate that the parties seem to be working together, although there is a lot of adversarial tension between your clients. I think that particularly with discovery disputes, it is helpful to distinguish between your responsibilities as an attorney and your responsibilities to your client. But what I'm hearing is that there is some opportunity to continue to work together to resolve some of these disputes, so that the only matters that the court needs to address are those that truly can't y'all have a disagreement regarding. But Mr. Lamb, it sounds like your concern with postponing the court's intervention is that it would require the entire subpoena process to have to begin all over, which is a poor use of your time in litigation. Have you and Mr. Kennedy or Ms. Daniel discussed the possibility that you attempt to work towards a resolution, and Ms. Daniel or Mr. Kennedy, that your client would not require another subpoena? I mean, if you all could work to a reasonable scope of discovery, it would allow that artificial pressure of a subpoena to be removed so that you all can truly get down to the Medicaid CMS review, the search terms, the time period that's in agreement, and just come to the court with, these are the 5 things that we simply have a disagreement on with respect to scope.
Your Honor, that's exactly what we were seeking in the agreement that Mr. Kennedy was attempting to strike with Mr. Lamb, was that the pressure of the subpoena would be removed and that they would come to an agreement on all of the terms, and then come back to you if necessary on things that are finally, could not be resolved. But we're here today because we hope to get a ruling from you on the objections and to narrow the scope of the discovery items so that we don't have to come back.
Well, here's the problem. Sometimes the court's intervention on an academic ruling on an objection actually prevents parties from doing what they need to do, which is work together. And you all know your case better than I do. You all know the scope better than I do. You all also are well aware that I make myself available all of the time. It's not like you have one shot at this today, and if you don't get it resolved, you're going to have to wait 2 weeks. There's no reason why you could not take the rest of this week to try to resolve this and come back Monday or Tuesday to the court, and we continue this hearing after y'all have had that opportunity to limit your dispute to those things that truly cannot be worked out, which is fine. There is nothing wrong with a discovery dispute. What I try to avoid is an unnecessary premature intervention by the court that prevents true negotiation by the parties. I have found that doesn't help anyone. It actually causes more expense by you all and your clients. And so what I would prefer, given the tone of the responses and replies and the number of last minute responses and replies that to me suggest there is some movement, is that we continue this hearing until early next week to give you the opportunity to limit your disputes to those things that truly you cannot agree to. That is my preference. And since you all are all here, we can go ahead and look at our calendars and figure out what date would work for you all next week. I don't think there's anything magical about Thursday at 11 o'clock in the morning here right now.
Okay. I think that's a fair resolution, Your Honor. Ultimately, what Alliance wants is to know, what are we required to produce? And we will produce it once we know what we're required. But what they don't want to do is to have to produce a bunch of documents and then have them come back and say, well, now we want more, because this is going to be a huge undertaking for the client. And they're all working remotely. They just want to do it once. So
the problem, and I can understand the frustration and difficulty. The problem is I can't, as the court, limit a party's, you get one shot at the deal, because they don't know what's going to be in the documents. And so that kind of a limitation or expectation by Alliance would prevent Armanino from finding something in an email that says, well, hold on here, that's something we need to look into. But I do think that parties look like they are in a much better position before a court if they can say, you know, we have these disputes, but at a minimum, these are the documents that are well within the proper scope of discovery, and we're going to produce them right now. I think the discovery rules actually contemplate that you have to produce that which is clearly within the proper scope of discovery, and you leave to the court the determination of what truly cannot be agreed to. But I'm hearing from some of the responses that there is an acknowledgement that they are entitled to some documents. That's required by the rule. Now, if what you're saying is right, but logistically speaking, we'd like to do this search one time, then what I would suggest is work with Mr. Lamb to get to some agreement between now and Monday, let's say, and we'll come back on Monday and figure out, okay, so now that you have those agreements, what does the court need to rule on? And then do your search next week.
okay.
Are you all available at 10 o'clock on Monday? The only reason I propose that is I don't want you to think that by agreeing to work together, you're going to have a long wait for more time before the court.
Your
And
Honor,
Mr. Lamb, since it's your document requests, I'm sure you're the one that's more eager.
I can do it. 10 o'clock Monday morning is fine.
Ms. Daniel, Mr. Kennedy?
Yes, we're available.
Okay, and Mr. Travis, although you don't have much of a dog in the hunt, I'm assuming you want to be present as well?
I can be available, Your Honor.
Okay, great. Let's go ahead and continue this hearing. You all work to resolve whatever you can, and we will resume this discussion at 10 o'clock on Monday morning. Okay?
Thank you, Your Honor.